A decision has been made. The New Jersey Supreme Court has decided the Stengart v. Loving Care Agency case, and those of you who thought privacy should win, well, you win. The court held that under the circumstances, Stengart could reasonably expect that her email communication with her attorney on her personal password-protected web-based email would remain private, and that sending and receiving them on a company laptop did not waive that attorney-client privilege. Now, I'm sure a majority of us are guilty of using our Yahoo, Google, AOL, Hotmail, web-based accounts while at work. Well, Stengart did just that. She sent her attorney a few emails from her password-protected Yahoo account while she was using a company-issued laptop. Shortly thereafter, she quit and returned the laptop and then filed suit. Loving Care hired experts to create forensic images of the hard drive, and they found her emails. The company disclosed the emails to Stengart, but said that Stengart had no privacy on the files because they were used on a company computer. Well, the Supreme Court has decided that attorney-client privilege wins here, and privacy is allowed on those few emails that were sent. The Supreme Court based its decision on two basic reasons. It said, one, the adequacy of the notice provided by the policy was inadequate, basically a vague policy, and two, the important public concern raised by attorney-client privilege was more important in this case. The court says both of these reasons create a reasonableness of an employee's expectation of privacy. So how vague really was the policy? Well, the court says the policy didn't say that they had the ability to go into the computer and receive these images through forensic imaging. In addition, it didn't really define what they meant by personal emails. And finally, the policy did say that you could use the company computers for some personal activity. It was a mixture of words and not really explicit in the meaning as what it meant by personal. The court encouraged companies to have policies, but they highly suggested not to have a policy which had absolutely no personal computer usage, because this day and age, it's pretty unrealistic. Second, the court says attorney-client privilege is pretty dang important. Under the New Jersey Rules of Evidence, it says, quote, for communication to be privileged, it must initially be expressed by the individual in his capacity as a client in conjunction with seeking or receiving legal advice from the attorney in his capacity as such, with the expectation that its contents remain confidential. The court decided Stengart's expectations were reasonable because subjectively she took steps to keep her emails private. She used a personal account. She did not save any passwords while using her account. The account had a disclaimer. The emails had disclaimers at the bottom of each email notifying the reader that the emails were confidential in attorney-client privilege. Now, I spoke to a law professor that said the law is being practical rather than formal here. He says it's going to give corporations clear guidance about what is protected and what isn't. The court is explicitly saying you can't have these vague policies that don't give guidance to the employees about what is protected and what isn't protected. So what do you think about the decision? Do you think the court was clear enough? Do you think they got it correct? And do you think other courts around the country are going to follow this decision? Let us know what you think right here on eLessons Learn.